I'm Mark Breyer of the Husband Wife Law Team. I'm an actual trial lawyer. I'm actually in that well fighting for my clients, judges, juries, checking out law and crime sidebars, top 7 most heated moments between judges and lawyers. Let's watch it together and see what we see.
I got to tell you, I don't remember in recent history maybe any more heated moment between a judge and an attorney than in the Parkland school shooter trial out of Florida. After he pled guilty, all the jury had to decide was what should be his punishment, life in prison or the death penalty. And I want to be clear here. This was an exhausting trial. And there was a point when defense counsel objected to victim impact statements that were directed not necessarily towards their client, but in their view, more towards them and their own families. When they tried to bring this issue up to Judge Elizabeth Schur, let's just say it didn't go very well.
These people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking. Miss McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also improper. I don't remember any comments about any children, and if there was, it obviously didn't, it came and went without me noticing it. Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
I have never seen that. I've seen judges get really mad. Admittedly, this is a different kind of trial, and judges in most jurisdictions are elected. So in addition to everything else, they have re-election to worry about. And I don't know what this judge was dealing with, but she deals with it in this whole trial. It builds up, it builds up. He talks about the judge's kids. So I've never seen you're excused, but I have seen threats of contempt and of civil contempt. So the you're excused thing, he's representing the client as a public defender. So generally, an angry judge might actually put him in contempt or threaten contempt. So interesting to have her go like a teacher, go to detention.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down.
So I actually have an issue with that. So here comes up the other lawyer, right? This is probably the boss over at the public defender's office, trying to calmly give the argument that that's what we heard and he was just making the point. Now you may disagree, but shutting it down, go to the back of the courtroom. It's a tough situation. I'm not going to pile onto the judge. They brought up her kids, bringing up the court's kids. Really, really bad idea. But his point, for all the other things he did wrong in that trial, his point was his kids got brought up. I did not see the victim impact statement or statements that he's talking about, but I would say this. I agree with the judge. You never bring up the judge's kids. Never. First of all, the judge is not the judge. The judge is the court. The judge stands for more than her or him. It stands for the integrity of the legal system. That's what the judge is in that moment. You owe respect to that judge and that court, no matter how attacked you feel.
There was another heated moment that came straight to my mind when I was coming up with this topic, the Kyle Rittenhouse trial back in 2021. Now, at one point, Kyle Rittenhouse took the stand to explain his actions. And of course, he was the subject of cross-examination by the prosecution. Here, prosecutor Mark Binger. And a couple of issues came up. One was Binger questioning Rittenhouse about his decision to remain silent after his arrest. Binger also wanted to point out that there was other evidence, prior statements from Rittenhouse, showing that he wished he had his AR-15 to defend against looters who were ransacking properties. And this was a problematic line of questioning. Judge Bruce Schrader took issue with prosecutor Mark Binger's line of questioning. While Binger is going to try to defend himself in this clip. You'll hear it. He said that the court left the door open to these inquiries. Judge Schrader admonished him quite expressly.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this.
So let's go on. You will hear this all the time if you watch trials. And if you ever go to a trial, all the time, once the jury leaves the room, open the door. Did they open the door? Some whole trials are based on waiting for the opportunity of one side or the other to open the door. In this case, before the trial started, they filed a motion that said, Judge, we want to question the defendant about this. And the judge said, no for now, and I will consider it at a later time. And it appears, at least in the judge's mind, that they decided that later time had happened, that the door had been open. That's not how it works. If a motion has been filed and you think the door is open, you have to come to the court, many times the sidebar. Can we approach, Your Honor? Your Honor, we think in that examination, they opened the door. They asked a question that allows us to go into this area. But generally speaking, you don't get to just decide on your own the door has been open and go for it. So you make these rulings before trial starts. That's what the judge has to do. The judge hasn't heard the testimony, hasn't heard opening, hasn't seen most of the witnesses. The judge is so limited in what they know before trial that it is not at all uncommon for a judge to say, I'll give you my answer now, but it's subject to reconsideration. You don't get to just assume the judge would now have changed their mind. You have to approach and ask the judge, depending on what the judge wrote and said pre-trial.
It was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony.
That's a pretty big deal. The judge had just said my pretrial rulings are still the same, and then you go into it, it's a bigger problem. The judge has just said nothing's changed my mind yet. You can't just assume they did. And let me tell you how problematic this is for the judges. The judges have a super tight calendar. They don't have a lot of time. They've promised the jury when the trial is going to end, and on top of that, they have another trial and another trial back to back to back, all scheduled. So if you create a mistrial by not listening to the judge has to restart the trial all over. It's a massive issue for the courts. They want you to play within the rules.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
That's exactly the bottom line. If you think the judge's ruling has now changed because of something that got brought out elsewhere, you ask the judge. It can be at a sidebar so the jury can't hear. Judge, can we approach? It can be at the next break, but you don't get to just go into something the judge has said no to. That is a potential mistrial where you have to start all over, and you could get fined, sanctions. Sometimes that you'll be referred to the state bar if you ever do something intentionally. It's a very big deal, and that's why the judge is so upset.
Let's go now to Delaware County, Ohio. Back in August of 2022, a man named Matthew Moore was on trial for the murder of his wife, Emily Noble. Body was discovered 4 months after she was reported missing in the woods. She was hanging from a tree by a USB cord. Prosecutors allege that Moore staged the scene to look like a suicide, but he was the killer. Defense counsel argued that it was possible that Noble had in fact killed herself. And as that back and forth was happening between both sides on the testimony and the evidence, this trial was notable for one particular outburst, one particular moment from the prosecutor. You see, Mark Sleeper and Melissa Schiffel were acting as prosecutors for the state. And on the 7th day of trial, the judge, Stephen Wolliver, wanted to move forward with the proceedings, despite the fact that Schiffel wasn't there in the courtroom. Now, according to Sleeper, the court was informed 2 weeks earlier that Schiffel wouldn't be in attendance due to a scheduling issue. Well, Mr. Sleeper let the judge know that he wasn't going to just let this happen.
Yeah, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
What? I want to assume, for the purpose of what I'm about to say, that the elected county prosecutor did give the judge notice, that the judge said it was okay, and now the judge, in spite of that, wants to go forward with the trial. You can't leave the courtroom. You cannot just leave that site unattended. Now, I understand you're forcing the judge's hand. The judges are wrong all the time. They're like referees. You know, they're right a lot, but we remember when they're wrong. They're wrong all the time. They're human. They have their own biases and prejudices. They don't put on a robe and become unstoppable forces who never make mistakes. He did not have permission to leave. Now, his argument is going to be, actually, I did because you, judge, gave us permission. But I do think he's risking getting in trouble with the state bar to just walk out like that. And he's also risking what the judge would do. Having said that, this does force the judge's hand. Is the judge going to actually move forward with trial with nobody there? If he may have said on the record, that's okay, you don't have to move forward. But this lawyer better be right. And even then, he better hope things work out after he leaves that courtroom.
How could I talk about this topic without bringing up Darrell Brooks Jr.? The man who went to trial out in Waukesha, Wisconsin. He was charged with 76 criminal counts for driving a red SUV into a group of holiday parade goers back in November of 2021, killing 6 people, injuring dozens of others. And at one point, he decided that he's going to represent himself. It was bizarre, from the arguments he was making to his outbursts that got him kicked out of the courtroom.
This court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. He took his shirt off as well.
That's a tough situation. You have the right to represent yourself. There's an old statement, someone who represents himself has a fool for a client. You cannot effectively represent yourself, even if you're the best lawyer. There's so many disadvantages to representing yourself and for advocating for yourself. You're too biased to see everything, and there's no one there to counsel you on the bigger picture. But beyond that, saying I didn't do it is not as powerful as saying this man did not do it. Or more importantly, saying they can't prove I did it is not as powerful as someone else saying they can't prove he did it. There are so many downsides to self-representation. Being crazy makes it harder.
Threw people off the loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it. You're a
letting me
public
ask
servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me.
First of all, a judge can tell you what to do because the judge's courtroom, the judge actually, as much as it may offend you, doesn't even have to be respectful. The judge should show respect. The judge represents the court system in something bigger than themselves, but you don't get the right to just demand how you're going to be spoken to. And this whole you're a public servant thing, we've gone a little too far in a judge's courtroom to call them you're just a public servant, so you show me respect. This probably won't end well. You can see this judge. She's trying to make sure she stays calm, cool, and collected, which I have not seen this. Maybe she doesn't do. This will be good.
Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it. I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody, you don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I got one ear that work, and I heard that.
This is to benefit you, so that you understand
Ain't none of
your
this to benefit me. So let's
has
be clear
a prior
about that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice. This is the alleged record of ableist.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value.
Do you know how many people have gone to jail based upon the rulings a judge made, not the jury? What the jury hears, how it comes into evidence. The judge has so much power. Now, there are times you've got to push back on the judge. There are times you feel the judge is not being fair. There's times where you have to say to, in effect, this powerful referee, I'm going to make my point, so either you get it right or you get reversed. But everything he's doing is just getting the judge angry to hurt himself even more. On the other hand, I think maybe he's struggling with some other issues beyond just this.
Let's talk right now about Young Thug's RICO trial. We have to talk about the drama happening between the attorneys and Judge Glanville overseeing the case. You see, he runs a very tight ship in his courtroom, and the attorneys will know that. Because if you don't follow court rules of professionalism and decorum, oh boy, he's going to let it be known. Like, for example, one of the defense attorneys in this case was held in contempt of court and was ordered to pay a fine and buy his colleagues lunch.
I want to look something up. I want to see if the Young Thug trial was in federal court. No, county court. There's a lot of times when you see judges who run a super tight ship and get really particular about their rules, it's federal court. Federal court judges are appointed for life. They have way more support. They have fewer cases and they have power. You will file this on this color paper with this font. They often are way more particular and much more demanding than you will see generally in state courts around the country. So I was just curious if the judge was a state court judge.
Follow-ups on other business that we held a little earlier. Mr. Menendez, good morning, sir. You were supposed to buy lunch for your colleagues. Have you done that as of yet? You were supposed to have done that by March the 17th. Did you go to, I told you, Jason's Deli. Did you satisfy that prong of your contempt yet?
I don't believe I was, Your Honor.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. I just want you to pick a date.
Okay. Yeah. Whatever date is looking for Mason. That works for me, Judge. And also, I never saw the contempt order. I misinterpreted it.
Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt.
How do you not know if you're held in contempt? I'd like to rewind. Being held in contempt should be a big thing. Was the judge holding him in contempt, or was the judge going, I'm going to hold you in contempt unless you go buy them some lunch? And so they heard that very differently, and it's a big deal. To have been held in contempt is not a small thing for a lawyer. So it's a little bit odd how that either miscommunication or whatever was playing out there. I wasn't in contempt. Yes, you were. And I was going to say send you for 20 days. That's a big deal. That raises some real issues about how the judge found him in contempt, if he actually found him in contempt, threatened to find him in contempt. You know, contempt is something that's used in movies and TV shows a lot, and in courtrooms, not a lot. So it's an interesting moment, almost very odd to me to see a lawyer go, I wasn't held in contempt, Judge. And then he was kind of smiling and lighthearted. So the whole interaction means there's got to be more to that story.
To the next matter, Mr. Johnson, how are we doing on that paper? I mean, the importance of professionalism. Yours is due by the 28th of April. I'm just clocking. So we on track? Haven't started. Well, your better half said she's not writing it for you either, because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table.
We had a case in my jurisdiction where a judge ordered 2 lawyers to go to lunch together because they were arguing about everything. He even picked the place. This has got to be, 25 or more years ago. I understood it, right? It didn't feel like the judge did it a lot. I think the judge was like, you two need to grow up. You're going to go sit down and break bread, and we're going to get through this. Now we got him having lawyers write essays. Now at a certain point, is it about you, judge? Now you got 2 different lawyers, and you're having them both do different things. And look, you're the judge. I could be in your courtroom one day. And if I'm in your courtroom one day, pro hoc vice, I'm not attacking. I'm raising questions because this is not typical.
28, yes, at noon. Or you do 20 days. It's 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility.
A 17-page paper. A 17-page paper about treating one's opponents with civility. If it was that bad, maybe you should have held him in 17-page paper. Like, what is that about? There's more to the story. Maybe the judge is actually doing this lawyer a favor, but you combine that with the take your adversaries to lunch. Woo! What's going on in this courtroom?
Paper is to be published quality in APA format, and at least 10 primary and 10 secondary sources.
At least 10 primary and 10 secondary sources. I'm gonna make you take 3 days of your very busy life where you're out representing people to go show me that you will basically bow down and write this essay. Maybe he did something so absurd that the judge is being nice. Maybe. Or maybe the judge says, like, I have the power, what are you gonna do about it?
How about the Theodore Edgecombe case? This was the man on trial for first-degree intentional homicide out in Milwaukee County, Wisconsin, for shooting to death Jason Clearman. It was a road rage incident gone bad, with Edgecombe claiming that Clearman called him the N-word and to get the F out of the road after he says their car clipped him while he was on his bicycle. An altercation ensued after Clearman got out of the car. Edgecombe shot him. It was a case of, was this homicide? Was it self-defense? Well, there were a few times during the course of this case when Judge David Borowski got into these heated back and forth moments with Edgecombe's counsel. For example, here's what happened when the defense wanted to call a certain witness testifying about what would constitute a threat.
Mr. Brums has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat.
Your Honor, I would like the defense to name me one case where Detective Burns has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one.
So hang on, so would I. Well, a case number that occurred in Milwaukee County.
Well, the state hasn't asked for any type of addendum to Mr. Brums.
Counsel, I'm asking.
Well, Mr. Brums is not here right now, but
hang on, counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County.
Oh, that's not fair. First of all, in Milwaukee County, there's a bunch of judges. So I don't know who's right. I have no idea if this witness that they want to call has talked about the thing that he just represented to the court. What he's basically saying is prosecution saying this witness should not be allowed to testify to this issue. And the judge was leaning that way from the argument of defense counsel. Defense counsel going, whoa. We want to use this witness for us the same way the prosecution uses this witness against us in other cases. And the judge at the moment is going, well, unless he's done it in front of me, or you can give me the case number where he's done this somewhere else. Well, you know who might maybe know the case number? The prosecutor, if they've used him. Now, maybe they haven't for that. You know who else he could ask? The witness. Now, the judge said, you just represented to this court what this man has done. You are going to bring me case numbers where he has done that. Okay, fair game. But the idea that you need that case number right now, this witness could have done it 100 times. He's not going to know the case number where he's done it. He won't even know specifically many of the cases without talking to the witness who's testified. I get it. This judge is frustrated. Maybe the judge thinks he's being misled, but I don't think that's a fair request of any lawyer.
You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on.
Mr. Burns can testify to the cases that he testified in.
Name a case now.
We don't have that information.
And he's not testifying.
Right. I mean, he's testified in several cases.
Counsel. He's done it with other judges. Argument does not work with me.
But that's not true, because when you're trying to get someone in many cases to say qualify as a witness, I've never heard a trial judge going, well, I have not qualified this person as a witness in my courtroom, because how limiting is that? Well, I mean, very often when you're trying to get a witness to be able to testify as a witness, one of the questions you ask is, have you ever testified and been allowed to testify as a witness on this issue before? Yes. How many times? How many jurisdictions? And that carries weight. The fact that that judge hasn't approved, now ultimately that's not the yes or no by itself, but the idea that, hey, if it's not in front of me, I don't care. Come on. You, judge, we're dealing in a system where you're supposed to follow the same rules as the judge down the hall. So I get it. Like, there's more going on here. You can feel the judge is mad about a lot more than just this argument. At least it feels that way. And so I get it, but I disagree completely that if I haven't heard it in this courtroom in front of me, I don't want to hear it. If this witness has testified in certain ways and been allowed to testify in other courtrooms, that's something I should at least consider. Now, what the judges do down the hall is not binding on me. What appellate courts say is binding on me. This is a trial court judge. He doesn't have to do what other judges have done. But the idea that it's not even persuasive unless it happened in front of him, I disagree.
And then there was the time when defense counsel was questioning a member of law enforcement about whether anything was moved from the crime scene that would maybe tell a different story of what went down. This happened during the actual trial.
You don't know if other items have been moved from one place and put in another place. Objection, Your Honor. There is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, counsel, that there is no evidence of.
So I disagree again with this judge. The jury is watching. The judge just gave his opinion in front of the jury about the facts. The proper objection is not objection, Your Honor. There's no evidence that anything was moved. That is counsel objecting, making an argument for the jury. The right objection is objection assumes facts, not an evidence. And assuming it does, the correct ruling is sustained. The jury is to disregard the question or anything in the question suggesting evidence that the court has not heard. But that's not what just happened. There was a speaking objection to basically argue to the jury by the prosecution. And then the judge then stated in words, that's right, there is no, now there may be no such evidence. And maybe this lawyer should be held accountable for saying something if there's not a basis, because lawyers can't just make stuff up, believe it or not. We are required as officers of the court to stick within the evidence. You can't just go making things up that you don't have a good faith basis to believe have or will come in later. That's all true. But at this moment with the jury there, as frustrated as this judge may be, I think he got that wrong.
That is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question.
The other thing is he's showing his frustration with the jury watching. You may be as mad as you want at this lawyer, but the person he's representing probably doesn't think it's great if the jury sees you hate his lawyer, because that reflects on him. Now, you can't help it. Your lawyer does reflect upon you, good or bad. But I do think judges, as hard as it is, have to try to maintain an appearance of not being biased one way or another. You want to call the lawyer up and say, if you do that again, here's what's going to happen? Do it. You're the judge. Your courtroom. You control it. Front of the jury, you have to be much more careful, and I think that was a mistake.
So the InfoWars founder and host was in a very tough legal situation. He was sued by the families of those who lost loved ones in the Sandy Hook Elementary School shooting, as well as a former FBI agent, for comments that he made regarding the massacre, namely that it was staged, that it was fake, that it was a hoax, that the parents were crisis actors. They sued him under various legal theories such as defamation and intentional infliction.
And then the man failed with a long list of failures in there. If you ever get sued, do not ignore the lawsuit because you think you're right. That's not how it works. I think I'm right. I'm not going to respond. Then you're going to lose. You're giving up your defense if you get sued and you don't do anything about it in the court. So if you think you're right, respond. If you think you're in the wrong, still respond. Don't give up the ability and a platform to even lessen, or it could be an unfair punishment that you get, whether criminal or civil.
And Alex Jones actually automatically lost these lawsuits because he failed to abide by court-ordered discovery obligations. It's called a default judgment. I want to talk about the Connecticut trial where Norm Pattis represented Alex Jones. Very animated lawyer. And you know, he seemed to constantly interrupt the judge, Barbara Bellis, and she was none too happy.
And so what one does isn't what we're here to show. We're here to show what he did.
Right, but that's a different, Attorney Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now, but if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely, I'm literally almost begging you. I have no recourse but to do that. I'll start with Attorney Patty. What do I need to do to stop the comments and the call? Just tell me what I need to do. Do I need to hold one of you in contempt? Attorney Pattis, I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it.
Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen.
Hey, I give that judge credit. So that's how you get credibility. 2 decades, I've never held anyone in contempt. I've never sanctioned an attorney. Okay, so if you do it now, it's probably not like you've made 4 people write essays in one trial and maybe you don't have as much credibility. This is a judge who's been a judge for 20 years and has never fined a lawyer. So if she does it, you probably deserved it, right? And you could see she remained calm and respectful even if she felt they weren't. Put on the black robe, but didn't forget she's just a person. Give her a lot of credit. And I'll tell you, I don't know what ended up happening, but if she did hold somebody in contempt, if she did find a lawyer there, who's going to question it? In fact, you ought to question it the other way and go, how bad were you that in 20 years of lawyers showing up in this judge's court, this judge has never had to sanction anyone but until you. You know, that says a lot. Some credit to the Law and Crime Sidebar. Did a really good job. I really liked what they put together and how they discussed it. That was fun. Interesting way to kind of see in the courtroom and get those clips. So if you would like to hear me talk more about what actually happens in a courtroom, a lot of times that what's covered by the media and even online is people who haven't stood in the well and actually been there and had these issues come up. You want to hear more? Let me know what you like. Make sure you comment, follow, subscribe, like, do whatever you got to do. Let us know what you need. And YouTube thinks you're going to love this video right here.